If you're doing business with Chinese suppliers and relying on a standard US or UK NDA to protect your product designs, customer information, sourcing strategy, or manufacturing know-how, you may already be exposed, and most foreign companies don't realize this until the damage is already done. They discover the problem when their supplier suddenly launches a nearly identical product, or when their distributor tells them they've been approached directly by the factory, or when they find their own product being sold online, sometimes cheaper than they can offer it themselves. And at that point, they usually say the same thing, but we signed an NDA. The problem is this: in China, that NDA may not protect what you think it protects, and Chinese suppliers know this. Let me explain why. Most Western NDAs are designed around one core concept: confidentiality. They usually say something like, Party B shall not disclose confidential information to any third party without written consent. That sounds strong, and in a US or UK context, it often works reasonably well. But when you're dealing with Chinese manufacturers, confidentiality alone is usually not enough, because many suppliers can technically comply with that NDA, while still legally exploiting your business. Let me give you an example. Imagine you send your supplier a product design for a new medical device accessory. Your NDA says they cannot disclose your design to anyone else. So they don't. They keep it private. But 6 months later, they manufacture the same design themselves. Then they sell it under another brand. Or they offer it to your competitors. Or worse, they contact your customers directly and offer the same product at a lower price. You complain. You point to your NDA. And their lawyer says, "We didn't disclose anything." And legally speaking, they may be right. This is one of the biggest mistakes foreign companies make in China. They confuse confidentiality protection with commercial protection. They are not the same thing. A proper China-facing supplier agreement must usually include 2 additional protections: non-use and non-circumvention. Non-use means the supplier cannot use your information, designs, processes, or commercial knowledge for their own benefit. That means they cannot simply manufacture your product themselves and claim they never disclosed anything. Non-circumvention means they cannot bypass you. They cannot contact your distributors. They cannot approach your customers. They cannot exploit your supply chain relationships to cut you out of the deal. Without these clauses, your NDA is often just a polite confidentiality request, not real legal protection. And there's another major problem that foreign companies overlook. Even if your NDA contains decent language, it may still be practically useless if it's structured for Western enforcement. I see this all the time. The agreement is governed by New York law or English law. It's written only in English. It requires litigation in London or California. That may sound sophisticated, but from an enforcement perspective inside China, it often creates massive problems. Because legal protection is only as strong as your ability to enforce it quickly. If your supplier knows it would take you years and enormous legal costs to pursue enforcement overseas, your contract becomes far less intimidating, and suppliers know this. A contract that cannot be enforced efficiently in China often has very little practical value in China. This is why experienced foreign companies use what's called an NNN agreement instead of a basic NDA. NNN stands for non-disclosure, non-use, and non-circumvention. It's specifically designed for manufacturing and supplier relationships in China, and when properly drafted, it is usually written in enforceable Chinese legal language, governed under Chinese law, and structured for direct enforcement against the correct Chinese legal entity in a Chinese court. That changes everything, because now your supplier understands there are real legal consequences for misuse, not just empty foreign paperwork. So if your supplier agreement only talks about confidentiality, you are probably underprotected. And by the time you realize it, your supplier may already have your product, your customers, your margins, and your leverage. I'm Tom, and this is China Business Law with Tom. If your business depends on Chinese suppliers, manufacturers, or distributors, subscribe for practical legal strategies that help you protect your contracts, your IP, and your commercial position in China. Because in cross-border business, the contract you sign today determines the dispute you face tomorrow. Use my voice for the narrator.